So it's time to talk with a legal expert on some of the points South Korea and Japan could make at the WTO dispute settlement. Bhala, distinguished professor at University of Kansas Law School and senior advisor at Dentons, is joining us via Skype. Hello, Professor.
Thank you very much for having me. It's a pleasure and honor to be with you.
Likewise, the pleasure is ours. Once the case gets underway, Professor, South Korea would most likely rely on Articles 1, 10, and 11 of GATT to stress its points. What kind of arguments would the two sides make?
South Korea has legitimate grievances under the General Agreement on Tariffs and Trade, the GATT, and other World Trade Organization rules. Going right to your question on the merits of the Korean claim, the first argument is under GATT Article 1, the very famous most favored nation principle. No other country was treated thusly by Japan. Taiwan and Singapore remained on the list for bulk export eligibility. So that's one argument now that Korea is making. Now, Japan does not have an automatic defense under the MFN rule. However, it can make a few points. One is, first, there is no right of any WTO member to receive an export. I mean, Japan is not required to export these three items if it does not want to. The second legal claim that the Korean government is making against Japan is under Article 11, Paragraph 1 of GATT. That's the famous rule against quantitative restrictions. Now, how might Japan defend against the Article 11.1 claim? Well, first, it could invoke national security. Again, we hope it doesn't do that, but it could. And now, the third claim that the Korean government has brought is under GATT Article 10. That's the famous rule about transparency. And what Korea pointed out was that Japan implemented its removal of Korea from the bulk export list and put it on this individual export list requirement for licensing. It did that on July 1st, and it started implementing this new measure 3 days later, so that Korea never really had a chance to give comments, and it had very little notice. Now, Japan has a few defenses here. The first is Japan will argue it was negotiating in good faith with Korea for upwards of 3 years before this became a World Trade Organization case, and that Korea was not engaging with Japan in the negotiations.
Professor Bhala, then, to what extent, I mean, this is a central question about this discussion here. To what extent do you think this bilateral consultation, which is ongoing or underway right now, will contribute to eventual resolution of this case?
Yes, I think there's a very good opportunity for Japan and Korea to resolve this conflict through consultations. Under the Dispute Settlement Understanding, DSU, of the World Trade Organization, there is automatically a notice and comment period, generally 60 days. And that period can be extended. And that's a period for the two sides, the complainant, Korea, and the respondent, Japan, to negotiate a diplomatic settlement. And many, many cases since the WTO was born and the DSU started to be used by the members, many, dozens, hundreds of cases have settled and not gone the full adjudicatory process of a panel and an appellate body proceeding. I might also point out that if by December 19th of this year there are no new appellate body members, then the appellate body will cease to function. So Korea will lose and Japan will lose the ability to appeal any adverse panel decisions that might be in the case. And so that in itself is an incentive for the two sides to settle the case, because they won't have, as it were, a Supreme Court to which to appeal in Geneva. Now, there's another incentive to settle. If the case were to go to a panel, the panel, under standard WTO rules and practices, will submit in confidence a copy in draft form of the panel report. If either, so both sides will see that it'll be submitted, that panel report, just to the complainant Korea and the respondent Japan. That gives an opportunity for the two sides to look at that report and see, maybe we should settle this case because it's obvious the panel has ruled against us. Whether that's Japan that might be losing the case or Korea that might be losing the case. And that happens also in WTO practice.